And that's just the most recent. Virtually everything we're going to we're going to highlight some things that maybe remain to against. The procedure of the variance request as a meeting, and in anticipation of having a meeting next week. Yeah, right. Little hand is on the 7, I said the big hand is on the 12.
So it's that one for me.
I call up that section of the special session of the Town of Clear Lake Board of Zoning Appeals to order. Robert has prepared an agenda. The first item is introduction and a roll call. We won't be looking for a quorum this evening because we're not going to do any official business. This is simply a orientation session for the new members. We're just going to talk about all of the background stuff that goes into being a BZA member. We'll self-introduce.
Jessica Swander, 7382 East State Road 120.
I'm Jim McLean, 1226 Quiet Harbor Drive.
Walter Grabowski, 254 West Clear Lake Drive.
And Matt Rippey, 68 West Clear Lake Drive.
Matt and Jessica are our newly appointed board members. Talked to Mike Hawk about this, about an orientation session, and his response was, this orientation session falls within one of the exceptions to the prohibitions of the open door law, as long as you're not discussing the pending variance requests or taking any final action on those. We cannot. So, just by way of background. We're going to dispense with virtually all of the other normal agenda items, approval of previous minutes, budget items, applications, no hearings or anything else, because again, we're not doing any official. We're going to jump down to new business, which is the training section for the new board. And to that end, I'd like to just do a quick overview. I think it's a presentation that George Schenkel did to the board on the Board of Zoning Appeals basics. I'll be reading a bit, and please feel free to ask questions at any time on it. So it's just open, informal. Board of Zoning Appeals is a local government body that is empowered by Indiana state law to consider granting relief from the requirements of the zoning ordinance, in our case, the UDO. I assume everybody is at least slightly familiar with the fact that we have a universal ordinance.
Yeah, definitely familiar.
It makes very interesting reading when you have time. The BZA, so does the comprehensive plan, by the way. I highly recommend it. Robert has put together binders for you both, similar to the ones we've had, updated, newer than ours. And I think the comprehensive plan is included, and you will be getting a copy, an updated copy. Me too, of the UDO show. But have the same problem, and I won't want uncertain.
Actually, with the UDO, are you guys okay with digital copy of the UDO?
Mhm.
Okay. Right. It'll be on your guys' tablets when we get those set up.
How come I don't have digital? copy?
You do have a digital copy.
How come I can't ever find it?
Really easy. Okay.
We have to ask for another training session for the BZA and the last division of the care, just to learn how to use these things. I'm not an Apple guy, and I struggle.
Actually, when I was putting this together earlier, I figured, it would be nice to have like a training and document thing that's right available, so then that way you can pick up anything that we've gone over in the past as far as that stuff. So it should be relatively simple. I just haven't set it up yet, but
Okay. I mean, we could even just have I'll buy coffee and we could just do it. You know, again, without affecting the.
anytime, I'm in the office most of the time, always on vacation.
This is important. The BZA is considered an administrative board that is quasi-judicial in nature. A quasi-judicial entity operates more like a court than a legislative body and uses many standards and procedures like the courts do. BZA decisions are required by state law to be guided by specific criteria. This is important, findings of fact, and decisions are to be made based on those findings. And there's a period at the end of that sentence. The findings of fact are all that matter. Okay? Duties granting of variances, the variances can be from developmental standards, or they can be variances of use. Variances of use are very rare. I've never experienced one. Most all of ours are variants from developmental standards.
From use, meaning accessory lot, they want to change to something, some other.
Exactly. Variants of use,
Typically,
multifamily or something.
yeah, so
It's the.
if it's not something that falls under the special exemption clause, and someone feels that they have a just reason to go forward with, allow the use that they're trying to get done, but it's not quite done in the ordinance way. Outside of special exemptions, they can go for a use variance. Special exemptions are a little bit of a different process.
So when you get into the UDO, you'll find within each zoning district that there are identified special exceptions. That you could have a school or something in this district as a special exception. And that would require a board action to allow you to do that. Those special exception items are identified in that zoning district and on that page of the zoning ordinance. So you could do that. We never have, in my experience. So also, we would also adjudicate decisions when the zoning administrator makes a decision, it's possible for the property owner to disagree with that and appeal to us to override that decision. Again, hasn't happened in my experience, but the duties are variances, special exceptions, and override, and appeals of the zoning administrator's administrative decision. Hasn't happened. We're not gonna talk about those tonight in any depth or experience. Smokey, feel free to kick in there anytime. Membership, 5 members of the BZA. 3 citizen members shall be appointed by the town council president. Smokey, Matt Rippey, Jessica. 1 must be on the plan commission. We don't know who that's going to be yet. At our next meeting, the 11th, assuming we don't survive whatever it's gonna be, we'll be determining that person. 2 must not be on the plan commission, no surprise there. 1 citizen member shall be appointed directly by the Clear Lake Town Council. And that person can't be on the plan commission. At the moment, that seat is Kit Tyler. And 1 member will be appointed by the plan commission from its membership. That's me at the moment. I don't remember the plan. So eventually there's 2 of us on the plan commission. Me as a member of the plan commission and whoever will. Can have an alternate if agreed upon by all appointed. At the moment, that's not okay. Officers, BZA elects the chairman, me at the moment, vice chairman, Kit Tyler, at the first regular meeting of each year, so it's an annual. They also appoint a secretary, who is our zoning administrator, Robert Hall. The attorney attends variance hearings whenever. Now, I really wanted there because the variance hearings are very serious court type thing. And then he'll attend other public meetings on request. Regular scheduled meetings, the second Tuesday of February, April, June, August, October, and December. Those are the scheduled meetings every other month, second Tuesday. Special meetings can be had at the request of the applicant and paying $1,000 fee. Those would typically be scheduled on the second Tuesday of the month that we do not meet. So the others. Order of business, got to be careful about the open door law of the state of Indiana, and that means there can't be 3 of us talking about business at the same time without an open meeting. Order of business, chairman calls the meeting to order, introduction, roll call. 3 members constitute a quorum, 3 of the 5 members constitute a quorum. Approval of previous meeting minutes, budget items, and the appeals of applications of public hearings, old business, new business, discussion, adjournment. No surprises there. In public hearings, variances from developmental standards are what we deal with the most, and we'll talk about that a little bit this evening. I'm not going to talk much about, not at all, about use variances or administrative appeals or special exceptions now. Could we ever have a situation like that? I think that we would convene a special meeting with Mike Hawk here to give us some guidance prior to that hearing. Now, whether or not it'd be a special meeting, or it would just be some conversation before or during one of those hearings, because I have no real knowledge about what fits there. So variances from developmental standards. These include modifications of setbacks, building heights, parking requirements, landscaping, and other physical standards. There are 3 findings of fact that are required to all be agreed to approve the variance. The approval will not be injurious to public health, safety, morals, and general welfare of the community. Yeah, that's actually another one. The first one is appropriate notices posted, published, etc. Neighbors have got to, neighbors of the affected property in two different categories have got to be contacted in two different ways of varying degrees of diligence, I guess is a good word. First, where adequate notice is done, then non-injurious to public health, safety, morals, etc. The use of the second, third, defining a fact is the use and value of the area adjacent to the property will not be affected in a substantially adverse manner. You got to be able to say yes. And then lastly, the strict application of the terms of the zoning ordinance will result in practical difficulties in the use of the property. Note that hardship is not an issue. And so practical difficulties is a very nebulous term. And Indiana law doesn't do a good job of describing a practical difficulty. Robert, would you care to make a comment about practical difficulties?
Actually, my little blue book here, which was Indiana planning and zoning laws annotated, which was updated 2022. Talks about some practical difficulties.
It's a huge thing in all these cases.
Yeah, I was actually reading over it and see if I could summarize it, but basically. In determining whether compliance with the zoning ordinance will result in practical difficulties, and are so as to support the grant of variance, courts need to consider three things. So this is something went to the court at the state level, and the court said, this is how we need to weigh whether practical difficulty exists. Whether significant economic injury will result in the ordinance if it is enforced, whether the injury is self-created, and whether there are feasible alternatives.
I think if we have consensus that we might ask like to address what practical difficulties might be prior to or during the next variance hearings.
What's that?
I was just saying that maybe we could ask Mike Hawk for to speak to practical difficulties at the next hearing.
Well, it simply put, and we definitely can, but there has to be a unique circumstance that's present on the property for the practical difficulty thing to be present.
I hear you and I understand that. I just don't find that in the law.
Well, okay.
In reading the Board of Zoning Appeals basics, which is like a citizen guide to BZAs in Indiana, that's a copy in the binder. Robert?
Yeah, everyone knows that.
I believe that they address practical difficulties here too. I'm just going to leave it as an open issue at the moment because I am not comfortable in defining practical difficulty. Okay, so when I was talking about the variances for administrative appeals, especially section, I'm going to jump down to staff, the plan commission staff will be the zoning administrator on Clear Lake, Robert. Conflicts of interest, a member of the BZA is still qualified and may not participate in a hearing of the board concerning a zoning matter in which the member is biased, prejudiced, otherwise unable to be impartial, or has a direct or indirect financial interest in the outcome of the hearing. I don't think there's any surprises there. Ex parte communications for Indiana state statute. No person may communicate with any member of the Board of Zoning Appeals before a hearing with the intent to influence the member's action on a matter pending before the board. So you got, this is a court, your jurors, you're going to hear the arguments pro and con, you're going to make a decision. No influence ahead of time. All BZA contact regarding a request occurs within the official public hearing. The zoning administrator's staff report, Robert, including a recommendation, may be presented to the BZA prior to the public hearing. And in most cases, it will be, unless probably incapacitated or something.
One time,
Your staff report may be made, will be made to the BZA prior to the hearing.
yeah, yeah,
Appeals, each decision, the three findings of fact in the affirmative, each decision or the negative of the BZA is subject to review by a higher court. So if somebody feels that the decision was unfair or influenced or whatever, they can take it to court. And the town of Clear Lake must appeal. Public feedback, the town of Clear Lake, BZA and Plan Commission have developed and implemented a public feedback form to help manage public input received by the zoning administrator prior to a hearing. Form will be updated to the specific needs of each hearing. Results of the public comments received in the forms will be quantified and summarized by the zoning administrator for presentation at the hearing. So you're going to give us a report of the metrics. That gets kind of interestingly involved. During a public hearing, the BZA chairman has the authority to cut off repetitious or irrelevant testimony, and then there are various resources. So that's kind of a broad overview of what we're all about. The two new members just received a copy. Here's something of a acknowledgement form saying that you have read and agreed to abide by a code of conduct for elected officials of the town of Clear Lake. Please read it. I'm going to highlight just a couple of things in here that I think are particularly. Council conduct is another. Councils are composed of individuals with a wide variety of backgrounds, personalities, values, opinions, and goals. Despite this diversity, all have chosen to serve in public office in order to preserve and protect the present and future of the community. In all cases, this common goal shall be acknowledged even as the council may agree to disagree on contentious issues. Okay? Avoid personal comments that could offend other council members. Be aware of the open door law in the state of Indiana. Can't have a bunch of people getting together talking about BZA business. Be aware of written notes, voicemail messages, and email. Written notes, voicemail messages, recordings, and email should be treated as public communication if they're dealing with BZA topics. If they're dealing with things for the BZA. There's a lot more, but after clarification, but avoid debate and arguments with the public. It is the responsibility of the president to focus the speaker and to maintain the order and decorum of the meeting. Questions by council members to members of the public testifying shall seek to clarify or expand information. Avoid argument. No personal attacks of any kind under any circumstances. It is inappropriate for a council member to contact a board or commission member to lobby on behalf of an individual, business, or developer. So that doesn't apply. Remember, appointed boards and commissions serve the community, not individual council members, including the guy that appointed you. So we're here for the community. Inappropriate behavior by an appointed board or commission member shall be noted to the clerk treasurer or council president, and then there's remedies. Council conduct with the media. The president is the designated representative of the town of Clear Lake Council, present and speak on an official town position. An individual council member is contacted by the media or anybody else. The council member should be clear about whether their comments represent the official town position or a personal view. No surprises. Um, a couple of things. Electronic, electronic, God bless you, attendance at a meeting. Town of Clear Lake Resolution number 03-2022. This defines how you can participate remotely and when you can participate remotely. And you'll have a copy of this in your binders, and if not, we'll add it. 2022-03. I know it's referred to in rules of procedure, but the actual resolution itself is a little bit more detailed. So the salient points are the following procedures apply to a member's participation in a meeting by an electronic means of communication. Not more than 2 of the 5 members might participate by electronic communication in any one meeting. Any member, except in the case of a meeting called a deal with an emergency, any member who plans to attend a meeting by electronic means is required to notify the presiding officer within 48 hours before the meeting, so that arrangements can be made for the members' participation by electronic communication. So 48 hours notice, please. Board of Zoning Appeals member may not attain more than 50% of the governing body's meetings in a calendar year by means of electronic communication, unless military service, illness or other medical condition, death of a relative, or an emergency involving actual or threatened injury to personal property. So gotta be here for at least half, physically present for at least half the meeting. And then there's a bunch of things where Board of Zoning Appeals member may not participate by electronic communications if we're attempting to take final action on things that we don't do. Adopt a budget, make a reduction in personnel, initiate a referendum, establish an increased fee, establish or increase the penalty. I guess we might do those. Use the governing body's eminent domain authority or establish rate or renew a tax. I don't know if most of those would be struck from this or not. It's in the language at the moment. This actually is written. It's a policy for the whole town council, board, and planning commission. A member of the Board of Zoning Appeals may not attend more than 2 consecutive meetings by electronic communication. So there's got to be a meeting in between. 2 consecutive meetings max. Good. Any questions? Yeah, pretty straightforward. Rules of procedure. We're not going to go into in depth of this. I really suggest that you read through this one at your convenience. I'm just going to highlight a few things that I think are particularly. Variance request applicant may request a special meetings. Special meetings will be held on the same day of the month that we don't meet. And PFP, etc. Quorum again, majority of the Clear Lake Board of Zoning Appeals that is qualified to vote, 3 members shall constitute a quorum. Action of the Board of Zoning Appeals is not official unless authorized in a regular or special meeting by a majority of the entire membership of the Board of Zoning Appeals. There's another place a little later where we're going to talk about 2/3 majority, and that kind of hard to have 2/3 of 5. Oh well. Electronic participation is governed by that resolution 03-22. Residency requirement, resident must be a member of Members must be a resident of the jurisdictional area of the BZA, or they must be a resident, they must reside in Steuben County and own property within the jurisdiction. Hasn't been an issue to date, but for what it's worth. If a vacancy occurs among the members of the Board of Zoning Appeals, the appointing authority for that seat shall appoint a member for the remainder of the term of the vacating member. That's also true of the alternate members. Conflict of interest. We already talked about bias, prejudice, direct and indirect financial interest. The Board of Zoning Appeals shall enter in the board's records the fact that a regular member has such a disqualification, and the name of the alternate member, if any, who shall participate in the hearing or decision in place of the regular member. An alternate member shall be appointed by the same appointing authority of the disqualified regular member. So, absent, disqualified, whatever, goes back to the town council president or the plan commission or the town council to appoint it. We talked about ex parte communication. A little more. Variances. Findings of fact, we talked about these. For development standards, as for legal notices will not be injurious to public health, safety, and morals. The use of the value of the area adjacent to the property will not be adversely affected. And the strict application of the terms of the zoning ordinance will result in practical difficulties in the use of the property. Hearing procedures, I won't go through all of the various, John introduced the applicant in a case, blah, blah, blah. But what are significant here especially to a lengthy meeting, is that all persons giving testimony of the board shall complete a record of public hearing form. They're making statements as if they were under oath. Supporting comments will be heard from organized groups, committees, and individuals, 5 minutes max. Opposing comments shall then be heard. Speakers should try to present new points and not repeat previous speakers, 5 minutes max. The Board of Zoning Appeals reserves the right to question any speakers at the end of his or her presentation. The applicant will then get 5 minutes for rebuttals. Once the Board of Zoning Appeals has finished questioning the point brought up by the public and the rebuttals from the applicant, the public hearing will be closed. After it's closed, the Board of Zoning Appeals will discuss and deliberate the application, have the right to ask questions to clarify information. So at the end of all our presentations, we'll close the public portion of it. We'll discuss it and you can ask questions of anyone. Okay. All persons giving testimony to the board regarding any pending application or appeal shall be deemed to have given their testimony under oath. Person giving testimony shall state their name and address for the record prior to beginning testimony. Statements to the Board of Zoning Appeals made by the applicant constitute binding agreements, so it's pretty serious stuff. Drawings and displays, part of the case file. Every person appearing before the Board of Zoning Appeals shall abide by the orders and directions of the chairman. Chairman shall have the authority to cut off repetitions or irrelevant testimony. Discourteous, disorderly, or contemptuous conduct shall be regarded as a breach of the privileges of the Board of Zoning Appeals and shall be dealt with as the chairman directs. This is interesting. The Board of Zoning Appeals may continue or postpone any public hearing when it needs more time to deliberate. And really would like to have Mike Hall's input if we're ever going to consider that as a possibility. There's more about postponements. Notice of hearing, Robert's gonna handle the vast majority of that. But this becomes quite significant, especially to my sensitivities. Adjacent property owners shall be notified by sending a copy of the notice of the hearing using certificate of mailing service, with such notice being postmarked at least 10 days before the hearing date. Adjacent property owners shall be defined as all contiguous properties with the assumption that public right of ways do not exist. Addresses for adjacent property owners should be obtained from Steuben County property owner records. That's adjacent property. Interested property owners are a little further away, but they're defined also. Interested property owners who are not adjacent property owners shall be notified by sending a copy of the notice of hearing by regular mail, such postmarked 10 days ahead of time. Interested property owners shall be determined by creating a 300-foot buffer around the subject property, 300-foot subject property using the Steuben County GIS system. That's a function there that allows it. So I personally am very interested in the reaction of the neighbors. And I would ask Robert, please expend some energy to make sure that we get responses from the adjacent neighbors in all cases. Sometimes they won't respond. But I would really like to know what their feelings are of the impact of the variance request. Okay. And no surprises. Final disposition of cases, modifications, exploration, certification of action. An applicant may not withdraw a case after the hearing on the application or request has commenced. We've had cases where we were actually dealing with multiple variance requests for the same property, and when one failed, the second one was withdrawn. It's okay, but once the hearing starts, it's got to go to some kind of conclusion or postpone. At the end of all of this, the variance process, a certificate of action taken shall be recorded with the Steuben County Recorder to memorialize all variances granted after the project is completed. We have an open agenda item about talking about who does that. I think it was 10-4 or 9-3 or something at our last meeting. We made a lot of tweaks to this document, but the procedure, there were 2 open action items. This was one. You know, okay, we won't go any further with that. So we'll be talking about that. One of the things that we failed to do, I think, at our last meeting, we did elect chairman, vice chairman, secretary, but it turns out that we need a rules committee. You know. The Rules Committee shall be a standing committee of the Board of Zoning Appeals. The members of the Rules Committee shall be appointed at the first regular meeting of the Board of Zoning Appeals each year. So we're going to revisit that one, time permitting, at the next meeting. Here, this is my 2/3. Amendment. These rules of procedure shall be amended by 2/3 of the membership at any regular meeting or special meeting called for the purpose of amending the rules of procedure. Like 2/3 of 5 is 6.667. I mean, it's 3.6. So I mean, I guess we'd have to have at least 4 people voting. I don't know why it's 2/3 rather than a majority, but it'll be it. That's the change of rules. Couple more notes on variance, and then we can all go home. in talking about this is UDO. Article 9, variances.
Yeah, which if you guys, can actually turn to in your book. It should be. The first blue cabinet has the tab things for this, and so, and then at the back of it, it has the article. 919.
That's okay. This is just a couple of things. I just want to make sure that we don't overlook this. At the regularly scheduled public meeting, the Board of Zoning Appeals shall review the application for variance, supporting information, presentation by the presenter, information presented in writing or verbally by the zoning administrator or other department of agency, input from the public during the hearing, and then applicable provisions of the UDO. So we specifically want to go back to those after the public and before our discussion. I just want to make sure it goes on. Blah, blah, blah. Development standards, variance findings of fact. The Board of Zoning Appeals shall make the form of a general statement. Disapproval of findings shall specify the reason for non-compliance. And when you get into the deeper discussion of these things, that gets a little interesting. If the Board of Zoning Appeals finds all the findings of fact in the affirmative, it shall approve or disapprove, and with conditions and or commitments, the application for variance includes. So it is conceivable that the BZA would negotiate with an applicant on some topic. And reach an agreement with them that would be a condition of the approval. That then gets memorialized for posterity at Steuben County along with the title to the property. So it's doable. The Board of Zoning Appeals may require the owner to make a written commitment. Commitment shall be recorded in the office of the Steuben County Recorder. A recorded commitment is binding on the typo there, the property of the land, any subsequent owner of the land, and any person who acquires interest in the land. So if you were to say, we're going to grant the variance and allow you to build closer to the street, that's going to be binding forever. It goes with the property. Does it pretty much for almost got it. Might have been out yet. Conflict of interest, we've already talked about that. Ex parte, we talked about that, but let me read this. This is from, again, you have a copy of this, Board of Zoning Appeals Basic. It's a citizen's guide to being a BZA member in Indiana. Orange tab. Persons may not communicate with any BZA member before the hearing with the intent to influence the member's action. It's often referred to as ex parte contact. See Chapter 6, Ethics, for more information on ex parte contact. Since conflict of interest is self-determined, it's possible that a BZA member could feel prejudiced after experiencing unavoidable ex parte contact and decide to recuse himself from the case as a result. We talked about the various categories of findings. Fact. This is a readable document. I mean, it's not law. Yeah, rules of procedure. Indiana Code 3674/916 requires the Board of Zoning Appeals to adopt rules which may not conflict with the zoning ordinance. Interesting here is, point 4, the conduct of hearings do not rely on Robert's Rules of Order. It is much too complicated for local government public hearings. True. We fall pretty close to it. And last but not least, in doing the findings of fact, you'll preparing findings of fact, but there has to be not just a statement of a finding of fact, but there has to be a because statement. You know, we feel that this is not injurious to public health, welfare, and morals because it is being built to include quality materials by a professional architectural firm, etc. There gotta be a because. Anybody want to talk about anything? That's all. I just want to get us as kind of ready to go through the process. Mike Hawk will be here at the meeting on the 11th. We'll have a very scripted agenda. Anybody? Nate?
Just one comment, ex parte trumps, the open door policy. So the point is with ex parte, you can't even talk among yourselves. It's not three of you, but you cannot discuss the case.
Yeah.
Among yourselves either,
We,
because of ex parte. If you reread it, it says people. It doesn't say special people or certain people. It says people. All people.
we do not discuss.
Each is independent of the other.
Other than getting a staff report from Robert,
Yes.
we do not discuss.
I think you made it clear when you talked about us being jury members.
Yeah, we don't discuss a hearing issues or, I mean, you could, I'm sure that you could ask me, Robert, or the town attorney about some procedural issue involving variances in general, but not the specific one. Agreed? Nathan?
The only other thing I'd just like to add is that all elected officials and commission members and board members are here representing the community. And the way we can tell what the community is after is, you know, being out and in a social environment and pick up what folks are thinking. But in the absence of that, if you're not out and about, certainly the comprehensive plan tells you exactly what's on the community's mind, what they want and how they want their community run. And that is our touchstone to the BZA. It's a touchstone to the Plan Commission that we are here as an official representing the community, not our self-interest. So very, very critical point to have your orientation proper for the community and not for the self, for the individual.
As you invest some time in getting up to speed on the issues you're going to be confronting before or unfortunately after the fact sometimes, you'll come to understand that back in 2006, very diligent committee did a lot of work surveying the community, which gave rise to the plan, the comprehensive plan, which then gave rise to the UDO. And it's been a long road.
For clarity's sake, you cannot have a UDO without a comprehensive plan first. You have to, legislatively, you have to have a comprehensive plan. Then you write the ordinances. And the comprehensive plans of the community, the ordinances is sort of the law of the community. And then that is updated. We're due for another update of our comprehensive plan, probably this year, 2023. The last one I believe was 2016. And then the UDO has been updated as we progress.
Individual ordinances have been updated ever since. As you get into the Board of Zoning Appeals basics, the citizens guide. One of the very first things after powers and duties, they start talking about structure. And in Indiana, there are 3 different structures for BZAs. And it gets a little germane as you get further back into the document to know that we are, Town of Clear Lake's BZA is an advisory board of zoning appeals under the advisory planning law. We are not an area board of zoning appeals or a metropolitan board of zoning appeals. We are the first one that they mentioned here, which is an advisory board of zoning appeals. It has some minor tweaks to Indiana law, which can get kind of convoluted when you get into it. Thank you all for coming.
Thank you.
Appreciate your. Thanks, Robert.
Hi.